So now we can move into another kind of technologically based case involving unauthorized access. And so this case, like many of the kinds of cases that are decided under the CFAA, both on the criminal side and on the civil side, is a question of an employee who is leaving an existing employer and either forming a competitor or going to work for a competitor. So here we have some employees of this travel company, EF Cultural Travel, and they're going to form a competitor called Explorica. And what these employees do is they hire a computer consultant, and the consultant is going to develop a scraper program, and the scraper program is designed to glean information from EF's website about EF's pricing. And as you read through the case, you can see that EF is using some codes. Now, this isn't computer code, but these are just codes to make things compact, like maybe SD would be student discount. You know, that would be oversimplified, but they've got a large number of these codes, and if you are able to glean the codes and the way that they're pricing their tours for different packages, you would be able to kind of gather their pricing model, and then if you wanted to compete on price, and presumably this would be a very price-sensitive business, then you would be able to put together competitive pricing sort of in real time based on the knowledge of those codes. Now, there's sort of an underlying issue floating around in this case about whether these codes are or would be trade secrets. You know, why isn't this a traditional trade secret case? That could be part of the case. But where you have something that is sort of just internal codes that identify sort of standard discounts, it might be difficult to argue that's a trade secret. That's the kind of case in a trade secret case where if there's just a little bit of information that gets out on this pricing, or if there's any sense in which the kinds of discounts that are offered are kind of typical in the industry, it may be difficult to show that that's really the level of confidentiality of information that's a trade secret. Furthermore, if you can find it through a public source, even using some effort like a scraper program, it's going to be very difficult to show that it's a trade secret. So to have something like the Computer Fraud and Abuse Act to fall back on in a case like this can be really useful. Well, what's a scraper program? At this point, again, rather than me trying to explain it, I'm going to step back a little bit, and I'm going to show you a portion of a video available on YouTube from just a guy who does these videos on different aspects of computer technology. I thought this one was pretty well done and a pretty straightforward explanation of what a scraper is. So watch this, and then we'll come back and talk a bit more about the case. Okay, so welcome back. So the scraper is used by these consultants, and the scraper takes these tour codes. The codes aren't known to the general public unless you can get them off this website. And one of these employees makes this information available. The employee has a confidentiality agreement, so there is this contractual issue of breach of a confidentiality agreement. With confidentiality agreements, you should note that those also can be hard to enforce. Courts are reluctant to enforce non-competes and are reluctant to enforce confidentiality agreements unless there truly is confidential information that the business truly has a legitimate interest in protecting and that doesn't overly burden the employee. So even though there's this agreement, there's still going to be a question, yeah, but is this information really confidential? Was it really expropriated in some improper way? So in the facts of this case, the scraper accesses the website more than 30,000 times. It gleans 60,000 lines of data. Now, that sounds like a lot. The court seemed to be impressed with those numbers. If you know anything at all about kind of the data mining industry, and the little video that we looked at on scrapers mentioned the data mining industry, you know that actually this is not a huge amount of information. It's not that difficult to obtain. It doesn't really take, if you know a little bit about what you're doing with something like one of those Python programs that the video mentioned, It's not that hard to get this much information. This isn't really big data. This is sort of just typical, or maybe even in some ways small data. But nevertheless, the court seemed impressed that it's an amount of information that to go through the website manually to try and look at the HTML or the other underlying code and do this manually would be just about impossible. You really have to automate it to make it in any way efficient. So a preliminary injunction is granted to the plaintiff, and there's an appeal from the preliminary injunction. That procedural posture could be important, but courts, usually appellate courts, are going to look at a grant of a preliminary injunction with not a whole lot of deference. In fact, perhaps even de novo. So appellate courts are going to look at this and say, all right, I'm going to dig into, in fact, really was there a likelihood of success on the merits and all the other factors for a preliminary injunction. So here, the appellate court says, well, yeah, it would be possible to manually gather all this information, but essentially what this court says is this smells funny to me. In fact, the court even uses the word, it reeks of use or abuse of proprietary information. It just seems unfair. It seems bad. It seems sneaky to this court. And the court says goes beyond any authorized use of EF's website. The website is set up for customers who want to shop for these travel packages. It's not set up for competitors to be able to gather all this information from underneath sort of the nuts and bolts of what's underneath the actual public face of the website. And the court says the confidentiality agreement is relevant here. The confidentiality agreement does, this court says, help the court determine what the metes and bounds of authorized versus unauthorized access might be. And there's an issue also floating around about the damage or loss requirement in the Computer Fraud and Abuse Act. And as we said last week, that's really not a hard threshold to meet. This case is one example of that, where the court says investigation sums, things along those lines can meet the $5,000 threshold. You don't have to show that there's any physical damage to the computer. Kind of floating around underneath this is the question of, do you have to value this data that was taken? Does this data have independent value? And the court sort of wants to punt on that, and does so by talking about the fact that these investigation costs and other related costs count toward the threshold. Now, as you think about this Explorica case, probably on first blush, I'm guessing on first blush, as you read the case, you probably thought, yeah, this is, if the statute's going to cover anything, it's got to cover this kind of thing. But step back for a moment and think about why. After all, the data was not kept secret. The data was available publicly on the internet to anyone who knew enough for how to look for it. And as the little video that I showed you about scrapers suggests, this is not an uncommon technology at all. And I mentioned in class last week, Google uses scrapers to help populate its search results. You would not have search, internet search, without scrapers. Big data in this country, the data mining industry use scrapers to comb through publicly available sources on the internet to get data that isn't necessarily on the front-facing part of a website, but that might be in other parts, but that still are publicly available. In the United States, we do not have protection for databases. Copyright protection extends to certain kinds of information that might be in databases if that information is original enough to warrant copyright protection. But copyright law does not protect facts. Copyright law would not protect, 2-letter or 3-letter or small codes that relate to discount prices, for example. That almost certainly would not be individually protected by copyright. So in scraping data like this, you're not violating copyright law for the most part. In Europe, there is database protection. Europe has opted to create an additional area of sort of para-copyright or super copyright that protects the data in databases as such. The U.S. has made a policy choice not to do that, and that issue has come up in Congress over several times over the past several years and consistently does not pass. Now, why doesn't that pass here? I mean, you might think that there'd be some support. This is, after all, a pretty copyright-friendly jurisdiction. You have things like extensions of the copyright term because the Mickey Mouse, original Mickey Mouse character's copyright is going to expire, and there's lobbying, and suddenly we have the copyright term extended. You might think that might apply here, but here there's a really interesting tug. There are businesses that want to see databases protected. There are businesses that are data miners, and there's an enormous industry in this, and there are entities like Google that rely heavily on accessing otherwise unprotected data through automation that don't want to see it. So if it's not protected on the copyright side, should it be protected at all under the Computer Fraud and Abuse Act? And that's one of the interesting issues a case like Explorica raises.